Prospectus. Let's see the meaning of prospectus. In Companies Act 2013, Section 2, Clause 70, it is said that any document described or issued as a prospectus. Okay, any document which is described as a prospectus is called a prospectus. Any document issued as a prospectus is called a prospectus, and it includes red herring prospectus, shelf prospectus, or any notice, circular, advertisement, or other document inviting offers from the public for the subscription or purchase of any securities. So prospectus includes red herring prospectus, shelf prospectus, or any notice, circular, or advertisement, or any other document which is inviting the public to purchase or subscribe to the security. They are also included in prospectus. So what are these red herring prospectus and shelf prospectus? Let's see. First is shelf prospectus. Okay, when one or more issues over a certain period without issue of a further prospectus. Okay, if you have to make issues for one or more time over a certain period, then the company issues a shelf prospectus. Okay, when a shelf prospectus is issued in that condition, for next time there is no need to issue a further prospectus. The shelf prospectus is enough, it can be issued again and again. Okay, it is called a shelf prospectus, like it is in placed in a shelf and it can be used again and again. Okay, what is red herring prospectus? A prospectus which does not include complete particulars. It does not include complete details about the price and the quantum or quantity. Okay, these are red herring prospectus. What are the essentials of a prospectus? The prospectus contains an invitation offering to the public. Okay, the invitation is by the company or on behalf of the company. The invitation is to subscribe or to purchase. Okay, and the invitation is related to shares or debentures. Okay, these are the essentials of a prospectus. What are the contents of prospectus? The prospectus must contain main objects of the company, the number and classes of shares. Okay, the minimum subscription amount, the time of opening of subscription list. Okay, and the prospectus should also disclose matters specified in part 1 of chapter 3. Okay, all these matters should be disclosed in the prospectus, and the name of underwriters, if any, if there are any underwriters. Okay, their name should be mentioned in the prospectus, and the amount or rate of the underwriting, etc. These are the contents of prospectus. Now see true facts, that in prospectus only two facts should be stated. What does it say? Prospective buyer is entitled to all true disclosures in prospectus. Okay, a prospective buyer, okay, a buyer who wants to buy these shares or debentures, is entitled to all true disclosures in the prospectus. Okay, prospectus must tell the whole truth. Nothing should be concealed which ought to be disclosed. Okay, anything which ought to be disclosed, it should not be concealed. Prospectus must reflect company's real position and true nature of its venture. This is known as golden rule as to the framing of prospectus. Okay, while framing of prospectus, the golden rule is to make all true disclosures, that there should be whole truth, nothing should be concealed. Prospectus must reflect company's real position and the true nature of its venture. Okay, when all these are included, it is called as golden rule for framing the prospectus. It is described as golden legacy by Pagewood in Henderson and versus Lacan case. Okay, true facts. Now liability. Liability of whom? Liability of directors or person responsible for issuing prospectus for omission. Okay, for missing something, or fraudulent misstatement. Okay, incorrect statement. So how is the liability of these directors and the persons who issue this prospectus, in which there is omission or fraudulent misstatement? Damages for deceit. Disease is a tort, it means fraud. Okay, damages for fraud, compensation for the fraud. Essentials of fraudulent misstatement. When a statement is called fraudulent misstatement, if that statement is made knowingly, okay, the person knows that he is making the fraudulent misstatement without believe in its truth, he doesn't believe in its truth, okay, and or he made the statement recklessly and carelessly, whether it be false or true, he didn't care whether the statement is true or false, he just included it in the prospectus. Anyone who invests money due to fraud statement in prospectus can sue the person responsible. If his action is successful, he can recover full compensation for loss. Okay, if someone believes in the true in the fraud statement and invest his money and he loses something, he can sue the persons responsible. These persons, the directors and the persons who issued the prospectus, he could sue them and recover full compensation for the loss. Okay, the compensation is given under section 35, and the following persons are responsible. They are liable. Who are liable? Every person who is a director at the time of the issue of prospectus, every person who has authorized himself to be named as director in prospectus, okay, and every promoter who was party to the promotion to the preparation of prospectus, all these persons will be liable. Okay, rescission for misrepresentation. Okay, allotment can be avoided by the allottee if caused by misrepresentation. Okay, if the allottee came to know that there was misrepresentation, and due to it, by believing on that misrepresentation, he bought those shares, then he can avoid the allotment of the shares. He will get rid of his shares and claim the money he paid for them. Okay, under section 75 of the contract act, a person who lawfully resigns a contract is entitled to compensation for any damage sustained through non-fulfillment of contract. Okay, that person is entitled to the compensation for any damage also. Action is against company to have subscriber's name removed from register. When he will avoid the allotment, the company will remove his name, and the action will be against the company only. What are the essential requirements of action? When action can be taken, what are the essential requirements? When there is false representation in prospectus. False representation means positive misstatement. Okay, the misstatement should be in positive, not negative misstatement. Or there is concealment of material fact. Okay, this is first requisite if you have to take action. And then another is false representation of fact and not of law. The false representation should be of the fact. The false representation of law, if there is false misrepresentation of law, then in that case there is no remedy. Misrepresentation of law, no remedy. Example, if prospectus represents, in prospectus it is said that fully paid shares will be issued at half price, but the companies act prohibit issue at so much discount. Okay, so this is false representation of law. Okay, not of fact. A person buying shares, he should know what is the correct law. Okay, if he said that he bought the shares by believing in the statement, okay, then he will not get the compensation, because this is false representation of law, not of fact. Fact must be material, it should not be immaterial. Okay, a fact is material if it is likely to influence decision of an average purchaser and urge or induce him to purchase or restrain him from purchase. Okay, uh, the fact should be material. Okay, a material fact is if it is likely to influence the decision of an average purchaser, then that fact is called material fact. Reliance and inducement. Plaintiff should have acted in reliance on the statement of prospectus. Okay, plaintiff should have bought the shares by believing in the statement of the prospectus. Misrepresentation should be at least one of the inducements for his contract of taking shares. Okay, a person cannot complain of misrepresentation if he had means of discovering the truth with ordinary diligence. If the person could have known the truth by ordinary diligence, by ordinary common sense, and he did not do it, he did not applied his ordinary diligence, then he cannot complain of misrepresentation. Okay. By or on behalf of company, a company is not responsible unless it is shown that prospectus was issued by the company or someone with the authority of company like board of directors, or by promoters ratified by company. Okay. Company is responsible if the prospectus is issued by the company or someone with the authority of the company, or by the promoters ratified by company. If the prospectus is issued like this, then only company is responsible. If it is issued by anyone else, then in that case company is not responsible. So this was all prospectus. If you want the PDF for revision purposes, you can get the download link from description box or comment box. If you are interested, you can take it from there. Next will be doctrine of ultra wires. We will cover it in next video.